Hey there, this is Leslie Quinn. I'm a real estate broker and attorney here in the state of Florida. And I've been working with clients and with real estate for nearly 30 years. And one of the common questions that I get even to this day through real estate agents and other real estate investors and so forth is, what are the requirements of executing on a deed? Meaning, how can we make the deed effective, and who can be a witness? Okay, first of all, in Florida, we need two competent witnesses. A witness is a competent individual, meaning they're capable of understanding the significance of the deed. They can't be deemed by a court of law to have lost any rights with regard to their competency, of course. If it's an aged individual who, truly and honestly is, and it's always a discretionary thing by the attorney or whoever's, having the people sign on as witnesses. But for all intents and purposes, even when we do execution of other documents, is that these individuals have to know what they're signing, right? But they have to be also over the age of 18. Normally, you don't, and you don't want, an individual that is a family member, although it doesn't really specify that you don't have family members there, but they can't be a party to the deed, meaning they can't be a grantor or a grantee, or they can't own an interest in the entity that is either transferring or receiving the property pursuant to the deed. And if they're, lots of times we do transfers for estate planning purposes. If they're going to be a beneficiary of a trust that, we're transferring property to a trust, and then the beneficiary of that trust is that individual, we don't want that individual signing as a witness, okay? Because there is a conflict of interest there and a potential for the fact that, there is going to be a question down the road and litigation that the individual was not in their right mind when they signed over the property to the trust, or they signed over the property to an entity owned by the person who was a witness, okay? So we want to eliminate conflicts of interest and any potential for, claims that there was some sort of illegality or issue going on behind the scenes, okay? When we look at the notary, each deed has to be, the individual's grantor has to sign before two witnesses that watch them sign the deed, but it has to be before a notary public, okay? So the notary's role is really to acknowledge the execution of the deed, ensure that the person that is signing the deed, meaning the grantor, is the person that is truly and honestly legally able to sign that deed, and that it is the person named in the document, and that they're signing it voluntarily, okay? And there's no sort of coercion or manipulation that is going on. Now, notary is only an individual that sees them at one point in time, so it's not a guarantee that there is no, adverse circumstance that is going on behind the scenes. However, normally within a period of time, those issues may arise and be litigated, and that's what we want to avoid, okay? So when the grantor, we'll go through the process, is that the grantor, the person is transferring the property, they sign the deed in the presence of those two witnesses, okay? Again, those two witnesses have to be competent, over the age of 18. They have to produce their own driver's license and identification, and they also must not have a conflict of interest, okay? The witnesses signed the deed attesting that they saw the grantor sign it, okay? That the grantor was competent, that they signed it willingly, and so forth. Finally, the notary public actually notarizes the deed, completing the execution process. After the deed is executed, that deed is then filed in the county where the property is located. Okay. The deed is then returned to the individual, meaning the grantee that is receiving the property. Okay. Now that grantee may be an individual, it may be, a couple, whoever is now the new owner. It may be a trust, it may be a company, an LLC, and so forth. Okay. Now, complying with the requirements is very crucial for the validity of that deed. Failure to have the deed properly witnessed and notarized can lead to issues with the transfer of that property, potentially rendering the deed invalid and unenforceable. So, be sure to make sure that you have followed the deed execution requirements in your state. Each state, again, has its own laws. However, pretty much, on a consistent basis, even mortgages and so forth, because, we have mortgage companies that lend across the nation, is that, the process here is very similar to the process that occurs in every other state. Okay, so if you have any questions or concerns, do let us know. We're always here to help you with your real estate needs. Bye.